Good afternoon, everybody. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores.
Present.
Senator Orenshaw. Senator Lang. Senator Wynn. Senator Hansen. Senator Krasner. Senator Ellison. Chair Scheibel.
I am here. We will go ahead and get started in a subcommittee of the Senate Judiciary consisting of Senators Ellison, Krasner, Vice Chair Flores, and myself. Please mark the other senators present when they arrive. Otherwise, mark them absent, excused, if they do not make it out of their other committee hearings in time to get here before the end of our committee hearing. This happens every time I start in subcommittee. We have Senator Hansen present. We will come out of subcommittee and meet in a full committee of the Senate Judiciary. Still mark Senators Orenshaw, Lang, and Wynn present when they arrive, or absent, excused if we get through these bills so quickly that we're, okay, mark Senator Orenshaw present. And I'm just going to open up a bill hearing before I have to amend my introductory remarks again. So let's open up the hearing on AB 150. I'll invite our presenters down to the front here. In case you're new to this room, there are 3 chairs. There are only 2 microphones. Fight amongst yourselves. In order to turn on the microphone, there's a button on the surface of the desk. It looks like someone dropped a sticker. You have to press that. When it turns red, that means the mic is hot. So go ahead and speak when the mic is red. And with that, we look forward to hearing AB 150.
Chairs. Apologies. Okay. Well, good afternoon. I'm Assembly Member David Orentlicker, representing District 20 on the southeast side of Las Vegas. Thank you very much for the opportunity to present Assembly Bill 150 with Angel Hood, who's interning with us this session from University of Nevada, Reno. The need for this bill was brought to my attention by Tribal Judge Patricia Lindsay, who is joining us this afternoon to discuss the bill. Inevitably, judges make decisions that displease many people being judged, and people appearing before a judge may try to influence the decision through intimidation or threat, or may retaliate for an adverse decision. Accordingly, state law already provides a number of protections for judges, but these protections are not provided to tribal judges. Judge Lindsay can discuss the serious consequences for tribal judges from this gap in the law. I want to thank the members of the committee for hearing my testimony today. I deeply appreciate this, and as you'll hear from my story, which is in the documents that were provided at the assembly level, one of the exhibits, you'll have a written copy of them. My name is Patricia Lindsay. I'm a member of the St. Regis Mohawk tribe. That's in New York on the Canada border. I serve as Chief Judge of the Winnemucca Indian Colony Tribal Court and a conflicts judge for the Urington Paiute tribe here in Nevada, among several other tribes in other states where I serve as either Chief Judge as in the Cedarville Rancheria of Northern Paiute tribes and the Chemehuevi Indian tribes. I'm also the Chief Judge of the Bishop Paiute Tribal Court. My work takes me across jurisdictional boundaries of many tribes throughout Nevada and California. I'm a citizen of the state of Nevada and of the United States. I reside in the jurisdiction of Douglas County, not on the lands of any particular tribe. Tribal court cases include all civil and criminal cases that state courts see and range from probate to protective orders to homicide. I want to share with you 2 specific situations that I have experienced to explain why I'm here in support of the amendment to NRS 199.300 contained in sections 1 through 7 of AB 150. 11 years ago, on February 20th, 2014, I was serving as conflicts judge for the Colorado River Indian tribes in Parker, Arizona. That day, I was also appointed as chief judge for the Cedarville Rancheria of Alturas, California. I was sworn in telephonically because I was in Arizona. That first hearing was held telephonically for the same reason. Zoom and WebEx weren't really used back then. So picture me in Arizona presiding over a case on the phone while everyone else involved in the hearing was present in the court, the tribe's meeting room. The only reason I am alive and be able to present this today is because I was telephonic. The person that was the subject of a housing eviction that day pulled 2 loaded 9mm handguns from her backpack, killed 4 people that were present, and wounded 2 others. In fact, one of the people survived the first 8 gunshots. She pulled a knife out of the storage room there and cut his throat to kill him. She stabbed others. I heard the entire crime. I could not stop it. The jurisdiction at that tribe for crimes rests with the state of California under PL 280. Tribal judges in California are treated under the law the same as any other private citizen, although there is currently an assembly bill over there that may fix some of that. I learned that others were possibly involved in the planning of the mass shooting, sympathetic to the shooter, and lived in Reno. I live in Gardnerville. I sought to have confidential license plates for my car and that of my husband once I learned, and then I learned that here in Nevada, tribal judges are also treated as private citizens, so I could not get a confidential plate. I had to show that I was the victim of domestic violence in order to get a confidential plate here. So I was in a legal loophole. In 2023, I was appointed to serve as conflicts judge for the Winnemucca Indian Colony. I have since been appointed their chief judge. I presided over a very contentious housing eviction case once again. And during that case, you'll see that in the documents, I believe the order from the prior chief judge is included, as well as in the past a letter of support from the Winnemucca Indian Colony for this amendment. While the case moved through the tribal court, I became the object of a campaign attempting to convince me to stop serving as judge, disqualify myself, and abandon my work as a judge for that colony. There were Twitter and Facebook posts of my image. Information about my personal life, my family, and my work were posted online. Information from my LinkedIn profile, a letter writing campaign to my own tribe and every single tribe where I worked as a judge seeking to fire me. It was cited as a reason that the Washoe tribe felt that my service as their chief judge could no longer continue. Meantime, several incidents occurred on the colony lands involving charges of assault on federal officers and other charges. The chief judge disqualified himself due to threats against him and his staff. Anonymous letters were mailed to every single one of my neighbors by name using their voter registration info for every adult in their house, and they were sent with return addresses of the Winnemucca Indian Colony or my own home address with my husband's name on it. They were demanding that my neighbors hunt me down, using those words, to stop me doing anything they could to keep me from presiding over that case. I called Douglas County to report this. I was told by Douglas County deputies to report it to tribal police because it was tribal, even though I live in the county and none of it happened on tribal land. I found that under Nevada law, I was left with no recourse other than that of a private citizen. I reported it to federal authorities, but it falls short of an exception under federal law there too. Tribal judges now are treated a little more carefully, but for a long time we were not protected even under federal law. Here in Nevada, only one of the tribal judges at all of the 27 tribes here resides on the very same reservation where that judge is a member. The rest live off colony or off reservation. Some of us live in other states. Some are native as I am. Many are not native. This amendment would recognize, and we have to drive from our homes, so I drive to Winnemucca to preside there. And I've had to drive out to Duckwater, Shoshone when I preside out there. Tribal judges regularly drive state and county roads. This amendment would recognize the service we provide, offer a clear direction for law enforcement faced with the same investigative situations that I faced. I thank you for your time and consideration of this important amendment to the tribal law that will lead to a better way to protect tribal judges. Thank you. And I'm happy to answer questions.
Good afternoon, Chair and member of the committee. My name is Angel Hood. That's ANGELHOD for the record. So just for some further background on AB 150. So currently, state law makes it a crime to threaten or intimidate a judge, and penalties are greater when a person attempts to use or uses physical force against a judge, which includes assault or battery. Judges can request the Secretary of State and county and city officials, meaning recorders, assessors, or clerks, to maintain the confidentiality of home addresses, email addresses, and phone numbers. And judges can have an alternate address on their driver's license. Currently, though, state law does not extend these protections to tribal judges or their staff. AB 150 aims to add tribal judges to the list of public officials protected, and the adopted amendment ensures that these protections are extended to all judicial personnel within these tribes, as well as state and local court staff. The basic provisions of the bill are as follows. Section 1 adds tribal judges and their staff to the list of public officials protected from threats or intimidation. It also incorporates a federal definition of tribe. Sections 2 through 3 increase penalties for perpetrators of assault when they assault tribal judges or their staff. Sections 4 through 6 allow the personal information of tribal judicial staff contained in the records of the Secretary of State and county or city officials to be kept confidential. And Section 7, tribal judicial staff may request an alternative license or identification card.
David Orient Liquor. That concludes our presentation, and we welcome your questions. I apologize, but I'll have to slip out in a bit.
All right. Any questions from members of the committee, starting with Senator Hansen?
Thanks, Madam Chair. I guess the question is it proper to address you as Your Honor? Your judge?
You can call
All right,
me
Your
that,
Honor,
or you
the
can
question's
call
for
me
you.
Miss Lindsay, whatever you prefer.
No, the bill's...
Most people do call me judge.
All right, Your Honor, or judge, or whatever you prefer. Question on the jurisdictional issues with tribes. You know, a lot of the tribes have declared themselves sovereign nations now. A bunch of them in mind, Oahe, McDermott, Pyramid Lake, and so forth. I don't know what is the interaction there between their law enforcement, their court systems, and things like that, and I guess our nations. I mean, if they're an independent nation, are they literally seeing themselves as completely separate? And if so, do we, and we pass a Nevada revised statute, is it binding on those tribal rules, laws, or whatever that they fall under?
Well, this law actually would fill a gap outside of the reservations, or for instance, if there is federal Indian law is a year-long course, okay? I teach it to judges under a topic called the jurisdictional maze of federal Indian law. So the lawyerly answer is it depends on the jurisdiction, but tribes are domestic, dependent, sovereign nations. We are dependent to the federal law, but tribes were named in the Constitution, and so therefore we have a unique status. There used to be treaties with tribes, so we're different than other people of color, let's say, because we have constitutional recognition. But As far as the jurisdiction for law enforcement, tribal police have state police powers within the reservations already under Nevada law. So if a non-Indian offender commits either a victimless crime or a crime against another non-Indian here in Nevada, the state has jurisdiction. Right now, picture when there's a native victim, it could be a federal crime if it happens on the reservation. But what happened in my instance was letters were sent to my home. I actually had someone parked in front of my house, watching my house. That's in Douglas County. That's in the county. It's not on a reservation. And I couldn't convince initially local law enforcement that they had jurisdiction just because I happen to be a judge at a tribe a couple of miles from my house.
Okay, well, I support the law. I'm just kind of,
Yeah.
I'm trying to picture in my
No.
mind the concept. I can see why we need it. I'm just wondering, will you still have this protection if you end up being a judge at Pyramid Lake? Or,
Sure.
you mentioned Winnemucca. Would you also at McDermott and so forth?
Well, because I'm native, if something happened and it were and I were a victim and I were on the tribe's land, it would be concurrent tribal and federal jurisdiction.
Okay, so you would have protection then, and this
Yeah,
law would help you there
but-
as well.
But this covers the rest of the state where neither the tribe nor the feds have jurisdiction.
Good, well, you should be treated like any other judge, justice of the peace, right on up the line, and
Thank
so
you,
I
I
think that this law
appreciate
looks
that.
like it'll take care of that, so.
And I will say that the proposed bill here in Nevada is more expansive. I've talked to other tribal judges in other states where we're trying to figure out who's got the best protection so far. And this will be the most protective for tribal court staff and judges of any state that I'm aware of. California is just barely proposing protecting judges, and they haven't even gotten to talking about prosecutors, public defenders, court clerks. So I really like the bill here. It's wonderful.
Sounds like we need an extra carve out for evictions too, for some reason, huh? I don't know what that sounds like. And the most dangerous thing in the tribal courts are evictions, it sounds like, but anyway, thanks, Madam Chair.
Thank
Thank
you.
you for your answers.
Thank you, Senator.
And I agree, we do like being the best at things. Also, my colleague's questions kind of reminded me, and I don't know if this would be for legal or for you to weigh in. Part of the bill also directs people like the DMV, who only the Nevada Legislature has the authority to make laws for, to do things like provide those licenses with fictitious addresses. And so in that sense, I think it makes sense that it would be the Nevada revised, it would have to be the Nevada revised statutes that would govern where somebody who lives in Douglas County gets their driver's license, right? I'm saying nodding.
I think so.
Okay, we will move now to questions from Senator Ellison. I think had a question. Go ahead.
He happened to be here, so you could ask them that question too. But I'm totally familiar with some of the stuff that goes on in a lot of the different places, Humboldt County, McDermott. I spent a lot of time up there, McDermott and Humboldt, and we just had a shooting in down by Lee where the existing board and the old board got into a shootout. So it gets out of hand sometimes, but I'd like to see this bill get in more onto also JPs and some of these others, because I tell you, they have the same problem in justice courts.
Absolutely.
Yeah, and my wife worked there for 33 years before she passed, and a close friend of mine was the judge, and he had to chase one guy down the street and tackle him to get till the police showed up. So we have these situations almost everywhere. And my sister-in-law was the judge in Wells. So I see a lot of this stuff, and I know that it gets out of control. But I'd like to see us get something eventually in here to protect these judges and staff. But I see what you're going through, and I also seen judges in Ilko get beat up right off the reservation. So
It is a risk. And for a long time, we weren't recognized as real judges, and it's finally getting to where people realize we do provide a service. So thank you. I appreciate it, and I think JP's, I thought they already were covered and their
They
staff.
are in a lot of ways, you know, but it's a county issue when they're in that county where it needs to be statewide, because if somebody sees them, like say in Las Vegas or whatever, they can still be attacked. So I think
That's true.
it needs to have teeth into it, and I love the bill. I'm glad you're bringing it forward. Like I said, I cowboyed up there in McDermott and Humboldt for years and years and years, and I
They have a
rodeoed
lot
in
of
McDermott.
challenges.
Yeah. So, Your Honor,
Thank you.
I thank you a lot, and I'm hoping eventually that either we can get a bill out there.
Yeah, so I'm going to have a legal weigh in here. I think that the provisions apply statewide to justices of the peace. Again, like the DMV, it might be up to a particular jurisdiction to enforce it, but the protections follow the JP wherever they go within this state. But
That's good to know.
I'm going to ask Mr. Wilkinson to clarify.
Thank you, Chair. Yes, that's accurate. The provisions all throughout NRS apply to judges, state and local, at every level, basically, throughout the state.
Would that same law follow in protection of the judge here, even though she's a judge, she's sworn in, she's under federal, courts or trial? Would she be covered under traveling throughout the state as the other judges?
Well, that's the purpose of the bill, is to...
Well, I didn't know if it was already...
She would be covered throughout the state, wherever she were traveling, but yeah, the purpose of the bill is to protect those tribal judges and judicial personnel.
Thank you. We learned...
For the question. Other questions from members of the committee? All right, I don't see any questions. Thank you so much for being here to present the bill and to answer our questions. We will move now into testimony. If you guys want to take a seat back in the audience, I will invite those testifying in support of AB 150 in person to come forward in Carson City or Las Vegas. And we will start here in Carson City whenever you're ready.
Good afternoon, Alex Tanchek with Silver State Government Relations, representing Pyramid Lake Paiute Tribe and the Duck Valley Shoshone Paiute Tribes here in support. Thank you.
Good afternoon, Jennifer Noble on behalf of the Nevada District Attorneys Association. We'd like to thank Assemblymember Orentlicker for bringing this important bill forward, and we hope that you'll support it. Thank you.
All right, I don't see anybody coming forward in Las Vegas, and I think that's everybody in Carson City. So we'll go to the phones for testimony in support of AB 150.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we'll take testimony in opposition to AB 150. I don't see anybody coming forward in person to give opposition testimony, so we'll go to the phones for opposition on AB 150.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, let's try neutral. Anybody want to testify in neutral? We will start here in Carson City with in-person neutral testimony. Please go ahead.
Thank you, Chair Scheibel and committee members. My name is Shawneen Guerin. For the record, S-H-A-W-N-Y-N-E, last name G-A-R-R-E-N. I am the Douglas County Recorder, and I am here today also speaking on behalf of the Recorders Association of Nevada. We are speaking today in neutral specifically to sections 4 through 6. As it pertains to the ability to mark records confidential within the offices of the recorder, assessor, clerk, and Secretary of State's office. One of the efforts that legislators did in last session was pass through Assembly Bill 225, where recorders and clerks, we all recognized that the danger in this growing list of people who are receiving this protection and all of this started in 2017. And then each session, we've seen this list grow. And we understand that what was happening is essentially a special class of protected citizens was being created. And we were going to see this list continue to grow unless we did something that created a way for other people to also receive this protection who maybe have had existing threats or share in similar positions that may present a threat. And so if you refer to NRS 247545, 250145, and 293909. Those statutes, specifically, the wording in there is for any person not otherwise described. So you have the list of the described parties that are position specific, and then you have the ATOs, all the others. And this was done very specifically so that you guys don't have to come back session after session and expand this list, and so that the courts don't have to session after session change their forms to add another checkbox. You can literally just do this. Anybody, whether you're a tribal judge, whether you are an everyday citizen, whether you work for the government or not. Now, there are some distinct differences. I want to, for full disclosure, make sure everybody understands. One is that all the others are covered. They have to either substantiate a threat that exists or has existed in the last 5 years, or identify what their job is that would create similar threats. So they do have to substantiate a little bit. Also, the other key difference is that those orders expire in 5 years, and it is incumbent upon our offices within 6 months of expiration to notify the petitioner that their order is going to expire, and if they wish to renew it, they can go through that process. Part of the intent of that renewal process was to make sure that the protections that are perceived are actually still in place. Because if you've sold your property, if you've moved, if any number of things happens, that protection doesn't automatically get applied to your next residence. So those are some things that we just wanted to, for clarity purposes, make sure there's an understanding of. The other thing that I wanted to be sure and highlight that is different for recorders as opposed to, say, assessors and clerks is we don't have a single record for the voter or a single record for the assessed property. We have a list of records. And so it's incumbent upon the petitioner to provide in their sworn affidavit the list of any documents that might be affected and have this information that should be marked confidential because it's limited information that's redacted. So there's a lot of moving parts there, but all of our offices are very happy to work with any petitioners as they bring those orders in. Also, anybody who is covered by a fictitious address, that's already in the list. So if you qualify, whether it's updating that statute for an extended, provisions, or you're on the list as one of the other named positions, or anyone not otherwise named. So hopefully that provides a little bit of clarity.
Thank you. That does provide clarity, and I've been saying for years that anybody should be able to apply for this because all kinds of individuals end up in situations where they're facing threats and they might not be clearly domestic violence or clearly victims of crime or something like that. And you have educated me today on the existence of those provisions in the law, and I would love for you to repeat those statutes if you still have them in front of you.
I
Thank
do.
you.
I'm going to put my glasses on because I had to really try hard. Those are NRS 247.545, 250.145, and 293.909. And all of those were a product of last session, 2023 session, Assembly Bill 225.
Excellent. Thank you so much.
Thank you.
And I think with that, That completes our neutral testimony on AB 150. Unless our presenters have any closing remarks, I will close the hearing on AB 150. It's now my turn to go present in front of an assembly committee, so I will hand the gavel over to my esteemed colleague, Senator Flores.
Thank you, Madam Chair. And at this time, I'd like to open up the hearing on Assembly Bill 291. Assemblymember Jackson, welcome.
Good morning, Vice Chair Flores and esteemed members of the Senate Committee on Judiciary. I am Jovan Jackson, representing Assembly District 6. I have the honor of presenting Assembly Bill 291. This bill is designed to provide individuals with a genuine second chance to rebuild their lives following arrest or conviction. The ability to seal criminal records is a vital tool for offering Nevadans a meaningful opportunity to move forward after their involvement with the justice system. Sealing criminal records break down barriers, giving Nevadans a better access to jobs and other opportunities without the ongoing weight of their past convictions. Under current practice, even if a specific conviction is eligible for sealing, according to the state statute, courts can still consider other unsealed records when deciding whether to grant the sealing petition. This creates an all or nothing approach. For example, if an individual has one felony and 2 misdemeanors on their record, say the 2 misdemeanors are eligible to be sealed by state law, but the one felony cannot, that individual could be denied sealing of their record because of the one ineligible charge. Assembly Bill 291 seeks to change this by allowing for selective sealing of eligible records, even if the other records remain unsealed. Here are other 2 key factors of AB 291. Increase employment opportunities. Individuals may have specific charges on their record that are eligible for sealing but prevent them from securing employment due to the presence of other offenses that are not yet eligible. By allowing the eligible charges to be sealed, this will open the doors to greater work opportunities for Nevadans. Also, there is no protection for repeat offenders. It is crucial to understand that this bill does not allow repeat offenders to evade existing laws regarding record sealing eligibility. If an individual commits the same crime in multiple instances, say one was in 2021 and another was in 2022, they will not be able to seal those offenses until each meets time eligibility requirements set forth by state law. Sealing one repeated offense will not conceal the others that they do not yet meet the necessary timeframes. Vice Chair Flores, I will now walk through the bill with the committee. Section 1 has been deleted by amendment. Section 2 prohibits courts considering a petition to seal records relating to a conviction for another offense from considering any prior proceedings for which records have been sealed. Section 3 provides the provisions of this act apply to a petition for the sealing of records that is filed on or after October 1st, 2025. In conclusion, Assembly Bill 291 will remove unnecessary barriers to promote real fairness in our criminal justice system. Currently, Nevada already allows some records to be sealed even if others aren't. Assembly Bill 291 will make this a standard practice statewide. Simply put, if a specific charge on someone's records meets the requirements under state law to be sealed, then it should be sealed. This gives people a real opportunity to move forward. Thank you, Vice Chair and committee members.
Thank you, Assemblymember Jackson, for the presentation and walking us through the bill. Members, at this time, we'll open up for questions. Senator Ellison, please.
Thank you, and I'm glad you mentioned that because I sent a lot of people down to justice court to get the paperwork started, and then usually they got to get an attorney and go in to get the record sealed if there's no problems within so many years, I think. And you mentioned that they can get their records sealed, but what is the time period that this bill would be before, if they created a crime, say breaking and entering, and they got it sealed, how long, if they do it again, are they exempt, not, they can't ever get it sealed again? How does that act?
Jovan Jackson for the record. So each crime has a statute where there's a time limit where it's eligible to be sealed. Different category felonies, maybe 5 years, maybe 7 years, maybe 6 years. So say if they did get that charge sealed and they committed another crime, they would have to wait by state law, whatever time that is stated in state law. So if state law says, hey, you have to wait 5 years for sealing, then you have to wait another 5 years, even though that you have that original charge sealed.
Okay, because from what I understand, usually it's 10 years, I think. You had to have no crimes within that 10 years before you can get it sealed. Is that correct?
Jovan Jackson for the record. So each conviction, each arrest is different by state law. So a misdemeanor may be a year, a gross misdemeanor may be 2 years. Certain felonies may be 3 years, 5 years, based on the category of the felony. I know category A may be up to 7 years, category B, 5 years. So it really just depends on the offense or the conviction.
Yeah, because I've had people that did something stupid when they were in their 20s, and then now they're in their 60s and finally go get it sealed, and they've been good citizens ever since. It can be done under existing law now, but I swear I thought it was 10 years before they could actually apply. So, and then if they repeated anything in that period of time, it couldn't be sealed. I might be wrong. We'd probably have to ask legal that. So, but thank you.
Jovan Jackson for the record. So currently, right now, in state law, that could happen to an individual. They may have two things on their record, and one is not sealable by law, but one thing is sealable by law. Right now, currently, even if that one thing is eligible to be sealed, they cannot, in practice, they cannot seal the record unless the entire record is eligible to be sealed.
Other questions from members of the committee? Vice Chair Flores.
Thank you, Madam Chair, and thank you, Assemblymember Jackson, for the presentation. I just wanted to get it clear, and I think you indicated it, and maybe I just misunderstood, but really the crux of the issue is here, if conviction A was sealed and now you have conviction B, you don't want that while they're considering whether or not to seal conviction B, that they take into account that conviction A was previously sealed, correct? But because I think one of the hypotheticals you provided, you said there might be conviction A, which is a misdemeanor, conviction B, which is a misdemeanor, and then conviction C, which is a felony. And I think you indicated that you were concerned that the felony conviction may be a bar to the sealing of the misdemeanor conviction, but I think your bill mostly speaks to previously sealed convictions and making sure that they don't take into account the fact that you had a previous sealed conviction. Is that correct?
Jovan Jackson for the record, that is not correct.
And please clarify where I am wrong, please.
Jovan Jackson for the record. So this bill, the intent of the bill is to if you have multiple charges, multiple convictions on your record, that you are able to seal the individual charge that's eligible to be sealed by whatever's required by state law. If state law says that it takes 5 years for this record to be sealed, then we could go in and individually seal that record, regardless if there's other convictions on the record that's not at the criteria where it's eligible to be sealed. So if you have 3 charges on your record and only one is eligible to be sealed, you could seal that one eligible record without being denied because of the other 2 convictions. Right now, in practice, it's more of an all or nothing approach. If all your convictions are not eligible to be sealed, the courts could still deny your petition for sealing that individual charge that's eligible.
Okay, I think we're still a little bit unclear, and I think there are a couple issues going on here. First of all, I want to make sure that we're all looking at the same first reprint of the bill, right?
Jovan Jackson, for the record, I only have the bill remarks that were provided to me by the Judiciary Committee in the Assembly. I don't have the actual bill in front of me.
You came to a hearing without a copy of your bill.
Jovan Jackson, for the record, yes.
You are very lucky that some members of my committee are willing to hand you an extra copy, because I'm going to ask you to explain to us in Section 2, subsection 4, where the thrust of the bill is, which reference to which NRS provides the policy proposal that you're explaining to us. Because I know that Senator Flores and I both do record sealings. I'm familiar with not every single one of these provisions by name or by number, but I'm just trying to figure out, if we were to cross-reference these, walk us through how to cross-reference the statutes that are cited in your bill with the policy that you're proposing, if you can.
Jovan Jackson, for the record, you said Section 2, Section 2,
Subsection 4.
subsection 4. Jovan Jackson, for the record, I cannot answer that.
Okay, and I think that's because in reading this, and I've done what I can while I'm sitting here, just cross-referencing like 176A.245, for example. That's one that I'm familiar with. That is the statute for sealing a record after a case has been dismissed voluntarily by the district attorney. So let's just stick with that one and pretend all of the other references don't exist. The way I read the bill is the same way that my vice chair reads it, which is to say that in determining whether or not to grant a petition pursuant to the statute that allows for a record to be sealed once the district attorney has dismissed the case voluntarily, a conviction for another offense the court shall not consider proceeding for which the records have been sealed pursuant to, for example, that same chapter. So that says to me, if I'm considering sealing a record under 176A.245, I will not consider if a record has previously been sealed under 176A.245.
Jovan Jackson, for the record, that is correct. That was not the intention of the bill, but that is correct from.
So is the issue with the... Okay, I'm going to pass it back over to my vice chair.
Thank you, Madam Chair. And Assemblymember Jackson, I think I have clarity here now, because in the original drafting of your bill, that language was in fact being considered. And I think what happened is in the gut and almost replace of the original Assembly Bill 291, that language was replaced, Assembly Member. So I think that's where the confusion was from your presentation. But just for the sake of clarity, in this reprint, we no longer have that specific language that was alluded to and my understanding from the reading of it now, and we can always have our legal jump in, is that after the amendment that was considered, and I'm not sure, and I'm assuming it might have been through the committee, what the bill is now looking at is specifically on previous records that had been sealed, and now you're considering a new conviction to be sealed, that the court not look at that previous conviction that was previously sealed and to undermine that second seal that you're trying to do. But I just want to make that abundantly clear. And I think that's where the confusion was, Assembly Member. But now that we're rereading the original drafted AB 291, I think that's where you were alluding to the other language.
Jovan Jackson, for the record. Yes, Senator Flores, thank you. That's correct.
Okay, I appreciate getting clarity on this. Senator Hansen.
Thanks, Madam Chair. I guess it's a little broader question in my mind. Basically, when a record's sealed, it's kind of like, according to law, it's like it never happened. But for somebody in the public, like myself, when I hire people, we always do a thorough background check to make sure that when we're sending, in my case, plumbers into people's homes, that these guys have been screened to make sure they don't have a significant history. If an individual has committed multiple fairly serious crimes, if this passes, can these all be sealed so that the public will be unable to access the crimes that the person has committed? Because if, in fact, we're going to treat them like they never existed, and we do a background check, and courts have sealed multiple crimes, what protections do I have for the average member of the public so they can be aware of certain things that people have done, crimes?
Jovan Jackson, for the record. Thank you for the question, Senator. So this bill will only allow you to seal those convictions that are eligible by state law.
Okay, well, and I was looking through all the various, there's like 6 or 8 different NRSs, but one was felony, one was reentry, one was payments, one was dismissed charges, but the felony one kind of caught my eye. Can you get a felony conviction sealed?
Jovan Jackson, for the record, thank you for the question. Yes, by state statute, you are able to seal felonies, certain felonies, category A, B, C, D. They all have different time stipulations of when they're eligible to be sealed. This bill is simply saying that we're able to individually seal one conviction without it being denied because of another.
Okay, well, I got it. I mean, I'm just kind of balanced out. Obviously, I want people who've gone through the prison system, pay their debt to society, are going to reenter, to have reasonable opportunities, but I also want to make sure that the public has a right to know that this individual has, in the past, not always exhibited the best self-control in certain circumstances and may be a potential threat. So I'm kind of trying to balance these two things in my own mind, but I appreciate the bill, and thank you, Madam Chair.
Thank you, and I'm sorry to do this, but I think we do have to be clear, Assemblymember, that what this bill says that we have in front of us is that a previously sealed record will no longer be viewable to the court in considering whether or not to seal a record. The policy that you've been discussing, allowing for what we call a partial record seal, is not contained in AB 291. So if your intent is to bring an amendment to do that, that's fine, but we don't have that amendment in front of us. What we have in front of us is a bill that says that if you've previously had a record sealed, and it used to be that you could consider that in the next sealing, you're no longer going to be able to do that. And so I appreciate that I guess there has been some kind of misunderstanding about the amendment that your House adopted that was amended to your bill to produce the first reprint that you should be presenting from today. And so I guess you're going to have to make a decision if you want us to move forward with your bill as it came to us, if you're going to ask us to make an amendment, but that's up to you, Assembly Member. And with that, I think it's time that we move on to testimony. I'm sorry, Senator Krasner, go ahead with your question.
Thank you, Chair. I just have a question for legal, actually. Does somebody have to do their time and pay their debt to society before they can even apply to have their records sealed?
Well, I guess it sort of depends on how you look at that. There are many different statutes that involve record sealing. There's a period of time after which you can seal a certain sort of category of felony or gross misdemeanor or misdemeanor. You have, as referenced in the bill here, a lot of different specialty court programs that have specific sealing provisions following successful completion of those, like mental health court, drug court, veterans court, all of those different programs. So that's basically how they work. There are a lot of different sealing statutes with different criteria that you have to satisfy in order to have the record sealed.
All right, and with that, we will move on to testimony in support of AB 291, the first reprint as it currently is in front of our committee. Anybody wishing to testify in support is invited down to the front in person here in Carson City or Las Vegas to do so.
Good afternoon. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. We do support this bill and we urge the committee to support it as well. Thank you.
Thank you, Chair, members of the committee. Harrison Epstein, Harrison, Epstein, I'm a legal extern for the Clark County Public Defender's Office. Record sealing allows people to more effectively restart their lives. Having an open criminal record can be a barrier to finding jobs, housing, and gaining access to vital social services. By ensuring that past sealed records cannot be used against people going through the process once more, we are allowing for continued rehabilitation. Among other sections, this bill specifically protects people with records sealed after going through drug and alcohol treatment programs. People are only placed in these programs because they have serious addiction issues. And according to the National Institute for Health, the average number of recovery attempts for an individual is 5.3. Sobriety is not linear, and this bill will play a part in acknowledging that fact. People make mistakes, and ensuring that those mistakes will not be held against them forever allows for rehabilitation and reintegration with society. Thank you.
Sorry, the button wasn't working. Good afternoon, Chair Scheibel and members of the committee. For the record, my name is Tara Webster, T-A-R-A-W-E-B-S-T-E-R. I'm the policy manager with the Progressive Leadership Alliance of Nevada, here in support of Assembly Bill 291. I'm sure everyone in this room is acquainted with someone whose life has been negatively impacted by a minor arrest that was used to tarnish their reputation in ways that have nothing to do with their true character or conduct in life. Further, a dismissed criminal case should have no future legal implications for the individual. It makes it so a person is to carry that stigma for the rest of their life. The intent of sealing records is to allow people to rehabilitate and to continue to be productive members in the community. The Progressive Leadership Alliance of Nevada believes AB 291 is a solution to upholding fairness in our legal system and reducing lifelong stigma. I urge the committee to support this bill.
All right, I don't see anybody else coming forward to give support testimony on AB 291, so we will go to the phones, please, for support on AB 291.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, we will go to testimony in opposition to AB 291, starting here in person in Carson City.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association in opposition to AB 291. I want to start off by saying sealing is an act of grace. It's appropriate when a convicted person demonstrates rehabilitation. And critical to a judge's determination of rehabilitation is assessing whether a person has committed subsequent offenses while in their waiting period for another criminal offense. And our concern about AB 291 is that it removes judicial discretion to consider subsequent criminal offenses. The ability to review an entire criminal history of a defendant is important, and judges should have that discretion. In essence, the statute at issue here, NRS 179-295 sub 4, says that even though a sealed conviction is normally deemed non-existent for most purposes, a court still may consider it for purposes of determining whether or not other previous convictions may be sealed. And we use the term previous, but this can all be done in one petition. In 179-2595, this legislature has allowed a person to file convictions or requests to seal from multiple courts in one petition in front of the district court. So in essence, what a defendant can do is say they have 5 convictions in front of them. They can ask the judge to seal the newest conviction in time, and then argue because that newest conviction is sealed, then the second newest conviction should then be sealed, and then the third, and then the fourth, and ultimately seal the final conviction, even though when you look at the defendant's criminal history in total, none of those convictions should in fact be sealed. So this statute is extremely important in giving judges the whole picture. Now, it does not require a judge deny sealing. A judge could in fact determine that each one of those cases deserves to be sealed. But a judge could also look at those convictions and say, no, this defendant has not made a showing of rehabilitation, and thus I am not going to seal those charges today. What AB 291 does is remove judicial discretion, and that's why we are here in opposition. We should not tie judges' hands. The court should retain full discretion to determine when sealing is in the best interest of justice and community safety. With that, Chair, if there are any questions, I'm more than happy to answer them.
Good afternoon, Chair Jason Woodard, Nevada Sheriffs and Chiefs Association. We are in opposition to this bill as well. We'd like to echo the sentiments of the Nevada District Attorneys Association. We believe judicial discretion and for the judicial discretion to be able to see the entire picture creates for better case-by-case analysis and also contributes to better safety for both law enforcement and for the community. Thank you.
Thank you for your testimony. I don't see anybody else coming forward to give in-person opposition, so we will go to the phones for opposition testimony on AB 291.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we will take neutral testimony on AB 291. I don't see anybody coming forward to give neutral testimony, and so we will go to the phones for neutral testimony on AB 291.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then that brings us to the conclusion of testimony on AB 291. I will close the hearing on AB 291 and open the hearing on AB 387.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the Judiciary Committee. My name is Nathan Anderson. It is my honor and privilege to represent Assembly District 30. I'm joined today by Jonathan Norman here in Carson City, and I believe in Las Vegas we are joined by Marina Dahlia Hunt of the Nevada Coalition of Legal Service Providers. I am proud to present AB 387, which updates our minor guardianship statutes to better serve the families, caregivers, and children who rely on this law for safety, certainty, and family security when faced with an emergency or when a parent is, for a variety of reasons, unable to safely care for their child. We all realize a child needs an adult that they can look up to. A child needs somebody that they can look at for safety, for support. And it's not always just the big things. Sometimes it's just also a smile or an encouragement that it'll be okay. And the children that usually are in this situation desperately need this. Current language in NRS 159A is basically enables family and fictive kin, sorry, I cannot say that, to navigate safely through the system. There needs to be some updates, however. It has not been updated for some time. As a matter of fact, I believe Mr. Norman has been working on it for almost 10 years to try to get this language cleaned up. And so AB 387 updates the statutes in a variety of ways. And instead of me going over it, I would rather have an attorney who is definitely an expert in this be able to do so. So with the chair's permission, if I may turn it over to Mr. Norman to be able to take it over. Mr. Norman, as you know, is with the Nevada Coalition, the policy director for the Nevada Coalition of Legal Service Providers. With the chair's permission, if I may do so. Jonathan.
Chair, Vice Chair, my name is Jonathan Norman, NORMAN with the Nevada Coalition of Legal Service Providers. Relevant to minor guardianship, it includes Legal Aid Center of Southern Nevada and Northern Nevada Legal Aid. Both programs represent children in minor guardianship. Legal Aid Center in particular is appointed in every new minor guardianship case in Clark County. Some quick history on minor guardianship. Prior to 2017, both minor and adult guardianships were contained in one statute. Obviously, the needs of a minor who does not have an available parent and an adult who needs a guardianship are vastly different. Just the passage of time means most minors will exit guardianship by turning 18. In 2017, the minor guardianship statute we have today was split off into 159A, and the adult statute remained in 159. This change came out of this body and was the culmination of years of work by the Guardianship Commission. The focus of those reforms were rightly centered on adult guardianship, because the crisis that led to prison sentences, national coverage, and inspired a Netflix movie centered on the horrible abuse in Nevada adult guardianship. Minor guardianship was also improved in 2017. AB 387 builds on those reforms and will make NRS 159A better for the families and children who desperately need the safety and certainty that Assemblymember Anderson mentioned. We have worked with the Guardianship Commission to reach the bill you have before you, and there is a small conceptual amendment that came out of discussions with the Guardianship Commission just this past Friday. The chairs of the Guardianship Commission, Judge Schreinert from the 2nd Judicial District and Judge Gentili from the 8th Judicial District, as well as the members of the commission from the private bar, have provided perspective and ideas that have made this bill better at every turn. I'm grateful for their input. With that, I would invite my colleague, Ms. Dahlia Hunt in Las Vegas, to walk us through the bill, and then at the end, I'll briefly go over the conceptual amendment. Thank you.
Good afternoon, Marina Dahlia Hunt for the record, MARINA DALIA-HUNT. Good afternoon, and thank you for the opportunity to speak today. I am a team chief attorney at Legal Aid Center of Southern Nevada, where I previously, before moving to a different unit, served as the team lead for the Minor Guardianship Advocacy Program at Legal Aid Center of Southern Nevada. Over the past 5 years since our program was created, we, and largely I, have reviewed every single petition for guardianship filed in Clark County, and on our team of attorneys have represented thousands of children in the system. Guardianship over a minor is a concept most people are at least vaguely aware of. Often people envision minor guardianship being needed when a child tragically loses both of their parents. But in reality, in Nevada, that fact pattern covers less than 5% of the cases we see. The vast majority of cases involving minor guardianship derive not from the death of a parent, but because of social factors, like a parent struggling with untreated substance abuse or mental health, ongoing domestic violence or child abuse in the home, or a parent asking a friend or relative to take their child in because they're experiencing homelessness, incarceration, or deportation. Or, as we often see, a parent may simply have disappeared from the child's life, and a grown-up has stepped up to be the the guardian that that child needs. Back in 2017, when NRS 159A was created, the bill's presenter, Judge Walker, noted that 159A guardianship is largely sought due to circumstances that would otherwise cause kids to enter foster care. After 8 years of NRS 159A's existence and more than 5 years of legal advocacy in this area, we can tell you that assertion is absolutely correct. And there are changes that need to be made to the current guardianship law to better match the needs of the children in this guardianship system. What this bill contains are a number of child-centric reforms that will fill gaps and better protect the health, welfare, and best interests of children. So first, most individuals seeking guardianship do so without an attorney, and the guardianship system itself is daunting. Sections 3, 9, 13, and 14 of this bill simplify the service requirements to better ensure that children who need an attorney to care for, need an adult to care for them, don't have that need impeded due to arduous service requirements. This bill specifically changes the alternative service requirement from only allowing for alternative service via publication in a newspaper to any alternative service method allowed by the Nevada rules of civil procedure. In Clark County, our petitions for guardianship are denied over children if there's any imperfection in service, including if a parent's location is completely unknown. And when petitions are denied because of service, children will wait for up to 4 months to even have a hearing on the petition. This means that doctor's appointments can't be scheduled, IEPs are delayed, children may not be able to get enrolled in school, and children sit in limbo in the meantime. Section 4 of this bill requires a petitioner to provide some additional information to the court in their petition, namely whether they've ever had a child removed from their care by Child Protective Services and how they are going to meet the basic needs of the child. Because these cases often are resolved in just one hearing, the court needs to have access to as much information as it can at the inception of the case to make an informed decision as to whether to grant the guardianship. Otherwise, the next time a court may see the protected minor is 3 years after the guardianship is granted at a mandatory review hearing. Section 16 sets forth best interest factors for a court to apply when determining when a guardianship is appropriate. Without these factors, courts have little guidance and have historically relied on factors in custody law under NRS 125C.0004, which simply don't match the needs of children in guardianship. Sections 6, 7, 11, and 15 center the child and, following national best practices, clarify the preference for the appointment of an attorney for a minor in guardianship and the role of that attorney once appointed. It also clarifies when a guardian ad litem or best interest attorney may be appointed as well. Children are the most important people in these cases. Their lives and futures are affected the most of anyone involved, yet they have the least ability to advocate for themselves. Protecting their access to an attorney that only works for them also protects their best interests and protects their safety and security. In determining whether to grant a guardianship, this bill also requires both a minor over the age of 18 consent to the guardianship, and that the court must consider the wishes of a child at any age as a factor in deciding who is the most appropriate guardian. Children are the experts in their own lives. Even feeling heard in a proceeding, even if the child does not get what they wish for, is valuable. Sections 13 and 14 of this bill clarify and expand on the ability of courts to grant temporary emergency guardianships under appropriate circumstances. As written, the law currently provides the ability to seek a temporary guardianship for medical reasons with supporting documentation from a doctor for an undefined good cause shown. The issue with that is that for medical guardianships, someone who is not a parent or guardian has no legal authority to get the medical records that would then show the need for the temporary guardianship. And the undefined good cause standard has led to denials of almost every temporary guardianship petition that we have seen. Children need a safe caregiver. A child not having one is an emergency that can and does lead to their entry into the foster care system. To ensure that the court has multiple tools at its disposal, especially given that most of the petitioners in this matter are unrepresented, Sections 13 and 14 also allow for a court to schedule an emergency hearing on a petition for temporary guardianship if it feels that it has concerns for the safety of the child but does not yet have enough information to grant a temporary guardianship. Many parents also want to remain involved in their child's lives, even if they are unable to have them in their care. Section 18 recognizes that there is a constitutional presumption that it is in the child's best interest to be raised by a fit and suitable parent, and that a parent is presumed suitable to care for their child, rather than stating that a parent is presumed to be preferred for appointment of guardian over their child. There is no need for a parent to petition for guardianship of the person of their child. This section also clarifies the court must consider the suitability factors relating to the proposed guardian, not just the parent. Section 17, 20, and 23 of this bill clarify that presumption and clarify that the guardian has the duty to assist in facilitating an appropriate relationship with the parent under the circumstances. Section 37 of this bill changes the standard that applies when a parent seeks to terminate a guardianship and removes a punitive standard that undermines parental rights, and instead provides best interest factors for a court to consider, focusing on what is happening in the life of the child at the time and parent at the time the termination is sought, rather than what the parent was experiencing when the guardianship was granted. Sections 5, 19, and then 24 through 32 of this bill make changes on the estate side as well. The goal of all of these estate revisions is to simplify the law while protecting the estates of children, allowing the court discretion to allow a guardian to use funds of a child to serve their best interests. With that, I'm happy to answer questions. Thank you.
And Chair Scheibel, if I can just briefly go over the conceptual amendment. It only makes two small changes. In Section 10, subsection 5B, it adds "or for good cause." And that's in the instance, some of our courts, if there's not an attorney available for appointment, they may be able to appoint a GAL, and we think they should be able to do that, and they asked for that good cause. And then finally, Section 42 removes two sections from our deleted provisions. That is because in Humboldt County, they still rely on special masters or hearing officers to oversee minor guardianship, and we wanted to make sure that they could continue to do so. And I think we're ready for any questions.
All right. I do normally ask my members first, but since I'm going to have to run to present that bill, I'm going to ask my question, which is about medical guardianship. And this has come up maybe once or twice in this session, and I'm not very familiar with it. So I was hoping that you could, and I think that the problem that you mentioned is an interesting one, where the person seeking guardianship would be prohibited from getting the medical records to demonstrate that they should be appointed as the guardian. So maybe it would be helpful if you could just kind of walk us through, I don't know if there's a typical case, but an example of when medical guardianship would be sought, so that we can better, or I can better understand what that situation, what that process looks like.
Marina Dahlia Hunt for the record. Yes, absolutely. So it's actually quite common. So our kind of most easily accessible example is one that ended up in front of the Nevada Supreme Court. We had two children, one of whom was born with severe birth defects to his kidney and liver, and he required, there's one specialist in the entire state of Nevada that can meet his needs as to his kidneys. He was living in a U-Haul van with his parents for a year in the Nevada desert, and then his mom had a mental health crisis on top of that and dumped him off at a hospital. They knew their grandparents' phone number by heart, called to could be picked up from the hospital, and when the kid got to the grandparents, he was yellow. He was clearly in kidney failure. They immediately called the doctor, and the doctor was willing to kind of bend the rules and see them, but he needed imaging of the kidney to be able to see what was going on and see if he needed to be admitted to the hospital for emergency surgery. And the imaging company refused to take the kid and image him without a guardianship. So they petitioned for temporary guardianship, but they couldn't get the certification from the imaging company to then support their petition for guardianship. So it was denied. Those kids ended up in foster care, unfortunately. Another relatively recent example is we had a young girl come in who has Down syndrome. She had severe dental decay and was in just extreme pain. She could not communicate her needs due to her other disabilities. But again, the dentist was not able to extract her teeth without a guardianship. So it's very extreme medical examples, but also just avoiding unnecessary pain and suffering to children.
Thank you for explaining that. And so in that case where the child in kidney failure ended up in foster care, then were the foster parents able to get that medical guardianship and seek the medical care that the child needed?
Marina Dahlia Hunt for the record. So the Clark County Family Services sought consent for medical treatment from the judge, and he was able to access his care. He's doing fine. He's going to be adopted, but it wasn't an unnecessary entry into the foster care system just to be able to access this care.
Thank you. And I realize that, as I said, it would be the agency that would get the guardianship and not the foster parent. But certainly it seems like it would have been better for everybody if grandparents could have just had that guardianship and taken care of the medical needs rather than putting the burden on the state to take custody of that kid and get the medical needs taken care of. And I am glad that he is doing better, though. And that was my only question. So now I will move to questions from our committee. If anybody, Senator Krasner.
Thank you, Chair. Thank you for your presentation. I'm just looking at Section 18, subsection 2A, where it says the parent is unable to provide for any or all of the basic needs of the proposed protected minor, including without limitation. And so again, it's any, so it could just be one of these: food, shelter, clothing, medical care, education. So let's say the parents love their children, but somebody lost their job, and so they're doing the best they can. Let's say they can no longer afford their health insurance, and they do not have health insurance for the child. Do we now take the child away?
Sorry, Marina Dahlia Hunt for the record. I'm happy to answer that. So I will say first, this is what the current law also applies this exact same standard. But second, no. So access to medical care would be more along the lines of the example that I provided, which is a child who has a recurrent severe medical condition, or it has teeth rotten out of their head due to never going to the dentist, never getting appropriate care, and a parent not attempting to seek access to bring them to get the care that they need, not losing health care. Similarly, being homeless, like without a house or without an apartment, would not mean that a child automatically needs a guardian. Relying on Medicaid does not mean that a parent needs a guardian. Children going to public school is 100% access to education. It's above and beyond that. It's not actually meeting the actual needs of the child.
Thank you, Chair. So just a quick follow-up. So let's say, again, it's this same family that's lost the job, or they're a little bit down on their luck, but they love their child, and they were going to the food bank to get free food. Would that be used as, oh, good, they're providing food, or, oh, we can use that against them to take away their child because they're going to the food bank and they can't provide it themselves?
Marina Dahlia Hunt for the record, no, they're providing food to their child. We're talking about children who are starving because they don't have any access to food, not a parent is using social services to meet the needs of their children.
Okay, thank you. I just want to make sure that we're not penalizing people that are poor and they love their kid, but they might be down on their luck.
And
thank you.
If I can just jump in, thank you for that question. I do just want to make sure that that section is already in the law.
I apologize for cutting you off.
Oh, Jonathan
State
Norman.
the name.
Thank you. Thank you, Vice Chair. If you look over on the next page, on page 20 of the bill, later in that section, that is just moved from that section up in the bill. So it's already in the current law. That section, we're not penalizing poor people. And in fact, in Clark County, those kids would get an attorney, and in Northern Nevada, would get an attorney from legal aid and make, generally kids want to be with their parents, and they would fight for that. So I just want to make sure that's clear.
Vice Chair. And so just since you brought that up, so since you're redoing this whole section, are you going to put something in there that says parents can't be penalized because they're poor or down on their luck?
Jonathan Norman for the record. So I don't know that, I think it is in extreme situations like the medical neglect, living in the U-Haul, situations that, but for a guardianship, the kid would enter child welfare are the kind of cases that we see, so not targeting people in poverty. But I'd certainly be open to any language. I think our courts do a pretty good job of avoiding guardianship for kids, and that poverty is not a basis, but I'd certainly be open to anything that assisted with that. I don't know, Marina, if you have any other thoughts.
Yeah, Marina Dahlia Hunt for the record. We completely appreciate this concern. We share this concern, as Mr. Norman mentioned. Our kids want to be with their parents when they're trying their best. It's an expensive time to have children. I will say, just anecdotally, most guardianships are uncontested. So generally, a guardianship is formalizing an arrangement where if the parents are struggling or if mom has passed, grandma or auntie or godparent has stepped up to take these children in. What we're talking about here, when it is contested, which is when Section 18 would be implicated, are really cases where, say, parents have been making the decision for years to purchase methamphetamine instead of purchase food. Not, we don't like that they're not giving, or this isn't meant to be a comparison between grandma living in a mansion and mom who's using social services to supplement, but still is meeting the needs of their child. There is a constitutional right to parent, and that is an awesome thing that cannot be overcome by a court thinking that grandma's going to feed the kids better than mom if both are able to feed them. So anecdotally, again, the courts don't grant guardianship because families are on food assistance or getting Section 8 housing or in public school or on Medicaid or using free services. That's what we hope parents will do. We're talking about the parents who choose not to do that.
Follow-up?
Thank you, Vice Chair. I appreciate what you're saying, but it doesn't say that in the bill. And I understand we're still using the old language, but you said you wanted to change the old language. And so I would really appreciate, if it's not a lot of trouble, to maybe just put some language in there about not taking away children from their parents because of poverty, just because they're poor, that not being, or just let it be a consideration, if you would be so kind. Thank you.
Senator Ellison, please.
Thank you, Mr. Chairman. Vice Chair. I had a lot of the same questions, but here's one of the ones I got. Does the state do anything and work with the parents to try to get them back up to where they could come put the families back together? Or is once they get out and get into the system, then they just end up being left there? That's my first question.
Marina Dahlia Hunt for the record. That's a great and complicated question. So one way through which children enter the minor guardianship system is essentially through a practice called hidden foster care, which is where a state has been made aware of concerns about especially neglect, but sometimes abuse. And the family has either come together to decide on their option, or the Department of Family Services has recommended that in lieu of the child coming into the child welfare system, a grandparent or whomever should take the child and seek guardianship. There is no additional social work support for a parent once a guardianship is granted, whether or not they consent to the guardianship. The onus is exclusively on the parents to address the problems that led to the need for guardianship, and some parents are able to do that and some are not. I will say also, guardians do not get almost any financial support for caring for children in guardianship, and that is kind of the cost-benefit analysis that guardians and parents are expected to make when they essentially agree to enter a guardianship system rather than a potential removal of their children into the 432B system.
And if I can, Jonathan Norman for the record, Senator, a few things that this bill does change that lend this new, if this went into effect, to better reunify families is we have the concept in here that if a parent is safe and the guardian is able to facilitate, and the guardian is making the decision about, is my daughter or son unable to interact with my grandchild because they're on meth, but they're making that decision. If they view the biological parent as safe, they are obligated under this bill to facilitate that relationship. So if they've been sober for 3 months, they can do visitation if they judge it's in the child's best interest. So that's something we haven't had before, is kind of maintaining and encouraging that family relationship in a way we haven't done in the past. And then also, previously, if a parent fought the guardianship, so opposed it, and it was granted, it was almost impossible to undo that guardianship. So it was an effective termination of parental rights, even though we were calling it a guardianship. So with the factors for terminating the guardianship, which are embodies what our case law is, it gives parents who have done the right thing and gotten back on track an opportunity to present to the court the reasons that the guardianship should be set aside and they should get the children back in their care, still protecting the child's safety, having the judge, make those decisions upon evidence. So those are two significant things that bolster parental rights and the maintaining of that relationship and the possibility of setting aside or terminating a guardianship. As far as financial assistance, there isn't financial assistance for guardians who step into the role. Would we love to see those grandparents who suddenly take in 3 kids, which is what we want families to do, right, is to take care of their grandkids. It's usually best for those kids. It's best for those families. I would love to see more support. I think in the fiscal climate of our state right now, that's not possible, but in another session when the economic forum is rosier, maybe we can advocate for those families to have additional economic support when a grandparent takes in 3 or 4 grandkids. So I appreciate that question. I think it's really important.
Got is I've seen where twice that social workers got upset and next thing you know, these kids are being pulled out of the homes. Big houses, great jobs, no issue there. But she said there was mental abuse, but couldn't find that. But the kids were removed from the homes, and that, when they did get them back, they had real psychological issues at that point in time. I think there's got to be a step in between some of these that if they're going to be moved, there needs to be a second party or somebody's got to look at the issues in here to see if they're right. Because, that family was totally destroyed, and that's not 1 but 2 that I'm aware of.
Yeah, Jonathan Norman for the record. I appreciate that when, we hope that there's a lot of, it sounds like that's probably a child welfare case where the children are removed by the child welfare agency. And I do think there's always room to improve that, and there's always room to kind of be more family and child-centered. And, whether that's pushing services into that home, which is the goal of child welfare, is to actually, it's to keep kids safe, but it's to maintain that family. And I know that there have been efforts in the state, encouraged by the federal government, to, as opposed to removing, if the child can be in that home with a safety plan, where maybe you're pushing family therapy or something to help that family, you don't want to remove kids because, there's trauma in the whatever abuse, if it's happening in the home, it's an adverse childhood, the ACE that we talk about. But just removing a kid from their parents, that's another adverse childhood. I'm forgetting the E, I think it's encounter, but we always just call them an ACE. And those have detrimental outcomes. They're indicators of not finishing high school, of substance abuse when the kids are in their 20s. So I definitely think we can do better on that front.
Thank you very much.
And next we have Senator Hansen, please.
Thanks, Mr. Vice Chair. Well, you guys see a lot of sad stuff, I got to say. And I suspect you rarely deal with, I guess we'd say stable two-parent families that are doing things well. The contested cases section, section 18, 6 and 7, where it allows somebody 14 years or older to basically reject a potential guardian. And then number 7 says that, well, if this 14-year-old, the court doesn't feel this judgment is sufficient, can push the guardian on him. That seems to be a little bit of an unusual circumstance in that now you're going to force a guardian on a child who's not really, a little child who may object to the guardian and it's like the court's creating a conflict there potentially if this bill passes. What's the
Senator
reasoning?
Hansen, I really appreciate that question, because in our initial bill from the last session, we did not have this language. We had that kids needed to approve of their guardian, and this was negotiated language with the child welfare agencies because they were concerned about the hypothetical if a child rejects a guardian and then the only alternative is child welfare, would they have a flood of cases? Now, I think it's totally legitimate to push back on that because nobody in guardianship or in child welfare can identify that this has happened. And the reason is judges know better than to force a 14 or 15-year-old somewhere they don't want to be. And the judge I practiced in front of would say, the kid's just going to vote with their feet and they're going to run away. And so this is trying to capture that kids have some agency in their lives while satisfying our child welfare agency partners. I do not think this provision is ever going to lead to a kid being forced into a guardianship they don't want to. I think our judicial bench is too wise for that. What this does is it allows the kid to look at the statute, and when you as an attorney are explaining to a kid what their rights are, it means a lot that they have this right. I don't envision this provision having much impact on how cases play out. I think it acknowledges that kids have agency and it satisfies our child welfare partners.
And I'd also like to add in on that, Assemblymember Anderson, for the record. This is not my world. I mean, let's just admit it.
Be glad.
Thank you so much. Wait, that's just not the Senate, right? Anyway, moving on. But judiciary it's something that I'm fascinated by. It's something that I like reading. It's something that I'm interested in. But the idea of guardianship is not my world. But I do know about 14-year-olds. And when you ask a 14-year-old, a 15-year-old, a 16-year-old, how are you feeling about it? It's not always just the idea that they will be there physically. When you ask how they're feeling, that allows them to emotionally be part of it too. And I think that's exactly what Mr. Norman was trying to bring in, is that having a child be able to be part of this discussion matters. And in the past, there are judges that have done that, and they've done it very well. But it's not always in the statute. This is allowing this to also be in the statute, that a child's voice, even if they're 14, matters. And not necessarily just because of what the law says, but more importantly, mentally and emotionally for them to have ownership of that decision as well. Thanks.
Makes perfect sense, although, Nath, I'd have to say judiciary is in your blood. How many times has your dad chaired judiciary? A bunch. All right, last question. Section 4, I think it's number 2, talks about, has ever been the subject of a report that has been assigned a disposition of substantiated. Is that just a typo? What is a disposition of substantiated?
Can you repeat that section, Senator?
Section 4, number 2J. It's on mine. It's page 6, lines 36 through 42. But line 39, I don't know if that's just a typo or what, but I want to double check.
Marina Dahlia Hunt, for the record. I can quickly address that. So it's actually not a typo. So within the child welfare system, they have different designations when a call comes in. So anyone can call and say, I think this person is abusing their child. Most of the cases are unsubstantiated, meaning that there's no evidence that abuse or neglect was going on in the home. Substantiated means that the child welfare agency determined that abuse or neglect was going on in the home. So our hope is to give judges information if someone is seeking guardianship over a child, whether or not they've had a finding that they had previously abused or neglected a child when determining whether they're an appropriate guardian.
Okay, so it's sort of language you guys use in your world. I got it. I just, when I read it, I thought, well, that doesn't sound quite right. So, okay, well, that was my question. So I'm glad to see that. I think this bill has a lot of really good checks and balances that need to be added to the existing system, since this is relatively new on the child-only side of this stuff. Thank you, Mr. Vice Chair.
And I know Senator Krasner did have a follow-up, please.
Thank you, Vice Chair. Appreciate it. And thank you guys so much for allowing me to ask questions. As you said, it effectively is the termination of parental rights. So it is a very big deal. Are the parents offered any services before the children are taken away? Are there any classes that we can refer the parents to before the child are taken away? Any kind of classes that the parents can take or resources that can be offered to these parents before we just get to it's over?
This is Jonathan Norman for the record. Thank you for the question. I do want to point out that now I think this bill walks us back from this being a termination of parental rights, because now we have clear guidelines on how a parent would go about setting aside or terminating the guardianship. So I think it's miles ahead of where our current law is on that, because the law, when a parent did not consent, was effectively a termination of parental rights, which we have done away with in this bill, and I think practice will reflect that. Ms. Dahlia Hunt may be able to answer the questions, but as far as on services, I don't, most of these cases, it is a parent has, left the kids with a relative, and the relative is cruising along fine, taking care of the kids, and then they need a guardianship because the school said, hey, do you have a guardianship? Or there's a medical issue or something like that. So the guardianship actually reflects the parents usually already have left the situation at that point. And in the cases where they're contested, I'm not aware that there are any services provided. And similarly to Senator Ellison's question, I would like to see a world where we are providing as many services that we can push into homes to prevent removal, whether that's child welfare or through an appropriate guardianship because a parent isn't able. I don't think we're in a position to do that this session, but it's certainly something that I think we should be focused on.
Thank you, Vice Chair. So what about maybe just language that just said classes would be offered to the child if deemed appropriate by the judge?
I think that we do, Jonathan Norman for the record, we do have, I know the second judicial district has a class, but I think that's for guardians so they understand that their rights. And I certainly think if we have classes that are available for free, I think that they should be considered. So I think that's something we can discuss. Mm-hmm.
Members, any additional questions? Seeing none, thank you, all three of you, for joining us. I'd like to invite all three of you to sit back in the gallery, and we'll invite those wishing to testify in support of Assembly Bill 387. If you could please come forward, Carson City or Las Vegas. Good afternoon, welcome. Whoever wishes to go first.
Good afternoon, Vice Chair Flores and members of the Senate Judiciary Committee. My name is Carissa Pierce, C-A-R-I-S-S-A-P-E-A-R-C-E, and I represent the Children's Advocacy Alliance as our Government Affairs Manager. CAA is an independent voice for Nevada's children with a mission to ensure that every child in Nevada thrives. And today I'm testifying in strong support of AB 387 as an initiative that centers children and families. AB 387 is detailed and thoughtful, a bill that was created through collaboration with the Guardianship Commission and with stakeholders who are frequently engaging with Nevada's guardianship process. Our families and guardians in Nevada deserve transparency and accountability in guardianship proceedings, and this bill ensures better representation and support for Nevadans navigating a challenging process, one that we can make more straightforward with the provisions outlined in AB 387. We'd like to thank the sponsor, Assemblymember Anderson, for bringing this bill forward, and thank the proponents of the bill, including Legal Aid and the Guardianship Commission. We urge your support for AB 387, and thank you for your ongoing commitment to Nevada's children and families.
And thank you for joining us. Good afternoon.
Good afternoon, Mr. Vice Chair, members of the committee. My name is John McCormick, J-O-H-N, last name M-C-C-O-R-M-I-C-K, Assistant Court Administrator at the Supreme Court, and the Guardianship Commission has been referenced a few times, and the court houses that, and we certainly appreciate all the work that has gone into it and the collaboration, particularly with the legal aid providers, and just want to put our support on the record. Thank you.
And thank you for joining us. Anybody else in Carson City or Las Vegas in support of Assembly Bill 387? Seeing none, BPS, do we have anybody wishing to join us over the phone in support of Assembly Bill 387?
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
Thank you. Next, we'd like to invite those wishing to testify in opposition to Assembly Bill 387, Carson City or Las Vegas. Seeing none, BPS, have we had anybody join us now in opposition for Assembly Bill 387?
Thank you, Vice Chair. The public line is open and working, but there are no callers.
Lastly, we'll invite those wishing to testify in the neutral position to Assembly Bill 387. If you could please come forward, Carson City or Las Vegas. Seeing none, BPS, one last time, anybody wishing to join us in the neutral position for Assembly Bill 387?
Thank you, Chair. The public line is open and working. There are no callers at this time.
And with that, any closing remarks you may have? I did see our Assembly member leave. With that, we'll go ahead and close out the hearing on Assembly Bill 387. Thank you again for the presentation. Lastly on the agenda, we do have public comment. Do we have anybody wishing to join us for public comment, Carson City or Las Vegas? Seeing no one in person here or in Las Vegas, BPS, one last time. Do we have anybody wishing to join us over the phone for public comment?
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
Understood. And with that, we have gone through today's planned agenda. Members, we will be meeting back in this room tomorrow at 1 p.m. This meeting's adjourned.